quo. How do you see yourself? Do you see yourself as an active Attorney General, and where do you go from here? Are you going to continue to dog and go after these companies that are fertile islands?
I don't see those comparisons as apt. Joe, the New York Attorney General is always going to be in a special position because they have physical jurisdiction over Wall Street and the New York investing community. And of course the laws of different states are different in terms of what authority we have. But I will say that it has been a priority for me. I talked about this extensively when I was running for this office last year. I have the background of being state treasurer. I have been an investor and been entrusted with the public's money and tried to take great care with it. And we were very wary of mortgage-backed securities under my watch because we were familiar with the foreclosure crisis in this country and did not believe a lot of the hype about the real estate markets. But I would say that it has been a priority of mine that we are going to work to hold Wall Street accountable. And to the extent they violate the law, they have to be held to account just like everybody else would be. And to the extent that their violations of law damage people, those people are entitled to compensation. And that's especially so when we're talking about investors and retirees and members of our pension systems in Ohio.
Can I ask a question about what you think your theory of...
Who's the questioner?
I'm sorry, this is David Siegel of the New York Times.
Okay.
The credit rating agencies have a nearly perfect record in court, as you know. What do you think will be different about your case?
Well, first of all, I'm not suggesting this is an easy case, but it is a case that we think is thoroughly justified on the facts and on our theory of the case. We believe, as we allege in the complaint that was filed today, that the rating agencies, in exchange for fees, departed from their objective role that they're supposed to play as a neutral arbiter of the risk of these investments, that they were in effect facilitating and encouraging and promoting the sale of these mortgage-backed securities by the way in which they handled their rating system, that at a minimum they were aiding and abetting misconduct by the issuers, and certainly they helped accomplish the distribution and sale of an immense number of securities at the highest credit ratings that did not deserve that status. And we believe the evidence will show that they knew that at the time that this was all going on.
But they've used, as you know, the First Amendment defense against precisely these kinds of accusations. Is there some other way, route of attack that you've got?
Well, it's one thing, David, to simply offer an opinion. That might well be protected by the First Amendment. When you are actively working with the issuers to figure out how to package the securities, to massage them in order to get to a rating, we believe that you're a participant in the business at that point. And we also think that they did directly aid and abet what was done in terms of these toxic assets. And again, that's our allegation. We believe that we will make that stand up in court. We think the facts will justify what we're claiming today. But obviously that's why you file a lawsuit, and that's why a court is a dispassionate, neutral determiner of whether you make your case or not. We feel confident about our case. That's why we filed it. We think it's important because of what's at stake here for investors and retirees in Ohio, and we will pursue the case aggressively.
How long do you think this was going to take to resolve each one of these cases that can go on for years?
You know, any good lawyer would tell you about a case like this. When you ask how long it will go on, I have no idea. So
hey,
we will
Rich.
see. Yes.
This is Cheryl Harris from the Plain Dealer. When you were talking about that $2 billion that you've recovered, is that money that's gone back into the funds, or is part of that money going to some of the private law firms that are helping you with these suits?
Those are gross settlements, Cheryl, in the cases. By the way, most of those cases, unlike the case we're filing today, were class actions, so there will be distribution to all of the class members. Our pension systems were part of the class, but by no means the entirety of the class. So the distribution procedure in those cases is complex and takes time, and so it's kind of hard to generalize at this point. but there will be significant recoveries to our funds in each of those cases. This case, in contrast, we're bringing directly on behalf of the funds, not as a class action. The 5 parties that I mentioned are our clients here, and we're pursuing this case aggressively on their behalf.
Thanks.
Mr. Cordray, this is John Stemple from Reuters. You were talking earlier about the failure of the issuer pays model or the problems with it. Is there some sort of way that model you believe can be, and for which you're prepared to go pursue this in the lawsuit? Is there some sort of way that portion of that model can be preserved if, for example, the rating agencies were to create some sort of a wall of silence or ethical wall or something to shield their individual analysts from dealing with the Wall Street firms directly?
Yeah, I'm not certain, and some of those questions really are for the appropriate regulatory bodies like the SEC and even Congress to take up, and the administration. What we are seeking here is a more modest undertaking. We believe that the rating agencies, their conduct was such that our pension systems were harmed by violations of law. We are seeking compensation for that. As the case unfolds and we get a better picture of what we are establishing and what they come to acknowledge over time, we can consider how this plays into corporate governance and changes going forward. I think that the regulators in Washington, hopefully there's a new activist era there, and that they're looking carefully at cases like California has brought here, that we're bringing here, that other states may bring as they pursue their own investigations and look at changes in the law to help prevent this kind of behavior going forward.
And one follow-up, it's actually a follow-up to Mr. Siegel's question a few minutes ago. On the